Good morning to all of you. Welcome to my professional ethics class. All of you are aware that in the last video we are here discussing the importance of the 7 lamps of advocacy. We have completed the topic of courage. Today we are going to discuss other 2 or 3 lamps like fellowship, judgment and honesty. Let us complete these 3 in one single video. We'll be quick. So, fellowship. What is fellowship? Even only in the court you are opponents. There is a public prosecutor, there is the defense lawyer in criminal cases. There is an advocate on behalf of the plaintiff, there is an advocate on behalf of the defendant. Everybody wants to success in his own arena. Every advocate wants to protect the interest of his client. He will try his best. Public prosecutor, he wants conviction. The defense lawyer, he wants acquittal. So for that, during the cross-examination, during the submission of arguments, definitely heated conversations will be there. But still, once the conversation or once the arguments are over in the court, by coming out, you are brothers. You are of the same legal fraternity. You are only opponents. You are not enemies. If you think like this, yes, definitely the concept of fellowship or the lamp of fellowship is achieved. So, what is fellowship? Fellowship means friendship with the colleagues. So, please remember, respect the entire legal fraternity. So, please remember, opposite lawyer, even the judge and the opposite client also, you have to give respect to them, you have to treat them like your brother. This is nothing but fellowship. So, the success of the advocacy profession lies in the so-called lamp of fellowship. You all know that advocates are the part and parcel of the administration of justice. You want to lead the judge to the side of acquittal, other side wants to lead the case to the side of conviction. Of course, judge is the final arbiter. He will decide the case. So, you fight for the justice. 2 lawyers, they fight for the justice. They struggle for the welfare of the client, for the good of their client. It does not mean that the advocates are the present advocate and the opponent advocate, like PP and defense lawyer, they are enemies. No, they are only opponents. There is a controversy and difference only on the particular issue. That's all. Not between them personally. The conflict ends then once they retreat from the court. So there they can happily meet in the canteen. They can discuss things. They can discuss. So this is what you have to know. There is no, in this connection, as regards fellowship, please remember, there is no difference of age, then experience, ability and appearance, money, all these things between the advocates. So all are equal. The court gives respects even to the senior advocate, equally to that of a junior advocate. Everybody will be given a chance to represent the cases. So please remember, therefore Daniel Webster says, the lawyers on the opposite side of a case, they are like the 2 sides of the 2 parts of a shears. Shears is a butchkatrije. So they cut which comes across them, but they do not cut each other. So this is more important. So that's why fellowship is an important lamp. Now we'll go to the next is judgment. Normally you may be shocked. What is this judgment? Who has to give judgment? It is for the magistrate or the judge. They have to decide and they have to get judgment. It's not that. Judgments mean the ability to foresee the counter arguments. Like while playing chess, yes, you will be able to assess the counter arguments. That is what is called judgment. But means by turning the pages of the case, by looking into the documents, then you must be able to judge whether it is a fit case to argue, whether there is any material in the case or not, whether you have to substantiate some more thing in the case or not. That is what is called judgment. Right? So judgment means ability to foresee the counter arguments. No doubt, we agree, advocate is not a judge and he is not the decision maker. There is no doubt in it. But when you accept, and an advocate accept the brief from the client, then on hearing the brief and on seeing the documents and also perusing the available evidences, the advocate should be in a position to assess the merits and demerits of the case and inform the same to the client. Of course, this is a typical issue, whether you inform the same or not, it is a personal thing. But you must be able to decide the merits and demerits of the case. If the merits are there, happy. If the demerits are there, you must look into so many judgments which will be favorable to you. So that is what you have to do. Suppose if even though if you know that the case ends in acquittal or the case is not suitable for filing, then better you explain or you encourage the petitioner not to go. Dissuade, not encourage, dissuade him not to file the case. Otherwise, what happens? The unnecessary filing the cases, they will consume a lot of valuable time of the court, not only time of the court, but the time of the public. So please remember, it causes huge loss to the other needy litigants and the public. So therefore, judgmental capacity is more important. So already I told you, judgment means the ability to appreciate or to anticipate the counter arguments and the ability to anticipate questions from the judge. So therefore, in this connection, 4 Ds are necessary. So these Ds are: number 1, skill towards self. So you must be very skilled. Then towards the client, second skill is toward the client. You must be able to assess what answer is coming from him. Then skill of the opposite liar. You can't estimate the other person. Your judgment on the other side, oh, this man, this liar, he will definitely put questions like this. And skill towards the judge. So don't be under impression that judge does not know anything. Jocularly, even though I am saying the judge need not do anything, no. Judge, you have to. So if you have these 4 Ds, like skill towards self, client, opposite liar, and judge, definitely you will be able to judge the cases properly. Coming to the today's next lamp, 4th lamp, that is honesty. You know, honesty is the best policy. Honesty means not being corrupt. So, but that means if you take up one's case, if you take up the case of the petitioner, you must treat it. You must not encourage the defendant to approach you. Even though approaches you, you should not talk to him. So that's why Blackstone theory, even though the decision or judgment should not only be given but should appear to have been given. So this is what is more important. An advocate must be honest to the profession. You should not do any act which leads to professional misconduct. So, of course, as a part of honesty, you have to disclose the real facts and circumstances and also the legal position to his client frankly. This is more important. Suppose if the client comes and says, come on, I want to file a case of section 138 Act, and he gives the check only out past 4 or 5 years back check ichcharu. Will it be admissible now? No, you have to tell them this check is not at all valid. Also present check check you must inform him frankly. That is what is called honesty. Second is, you should not resort to illegal practices. Already నిన్నే మన స్టూడెంట్ పేరు చూడటం అన్నా కూడా, సార్ మేము లాయరు ఫోర్జరీ చేస్తే లేకపోతే మ్యానిపులేట్ చేస్తే ట్యాంపరింగ్ చేస్తే, డోంట్ రిసార్ట్ టు సచ్ థింగ్స్. There the topic of honesty comes. So even you should not encourage your clients to do so also. Clients కూడా ఎంకరేజ్ చేయాలి. ఎందుకంటే don't prepare the forged and false documents. Definitely అవి మనకి కేవలము టైం ల్యాబ్స్ పనికి వస్తాయి తప్పితే డిలే చేయడం అయితే ఫ్యాక్ట్ విల్ ఆల్వేస్ రిమైన్ ఎ ఫ్యాక్ట్. యాజ్ అన్ ఎల్డర్ ఐఎమ్ టెల్లింగ్ యూ, నిజం అనేది నిప్పు లాంటిది, ఖచ్చితంగా బయటపడుతుంది. కాకపోతే టైం కోసం. అందుకనే సహజంగా మేము వచ్చిన కొత్తలో కూడా చెప్తుండేవాళ్ళు, ఒక 50 years బ్యాక్ డాక్యుమెంట్ దాని మీద రాస్తే సరిపోతుంది. కరెక్టే, 50 years బ్యాక్ డాక్యుమెంట్ మీద మీరు రాస్తారు. బట్ రిజిస్టర్ ఆఫీస్లో హూ హ్యాస్ పర్చేజ్ ద డాక్యుమెంట్ అన్నట్టు ఉంటుంది. ఇఫ్ యూ ఆర్ ఏబుల్ టు ప్రూవ్ దట్ యూ హ్యావ్ నాట్, దట్ ఫెలో హ్యాస్ నాట్ పర్చేజ్ ద డాక్యుమెంట్, వాట్ ద వాల్యూ ఫర్ ద డాక్యుమెంట్? వేస్ట్. కాకపోతే ఏంటంటే ఈ కేసు డ్రాగానే చేస్తుంది ఓల్డ్ స్టేట్మెంట్, అంతకు తప్పితే. సో డోంట్ గో ఫర్ ఫాల్స్ అండ్ సో కాల్డ్ ఫోర్జ్డ్ డాక్యుమెంట్స్, రైట్? సో The advocate should not participate in such activities. And sometimes, if you see, if the court observes, it becomes a content of the court. Please remember, and he has to be punished under section 12 of the Contents of the Courts Act 1971. So 10 minutes time is over. With this, I am concluding. So in this video, we have learned the 3 lamps of advocacy, like fellowship, then judgment and honesty. So in the next video, we are going to discuss the other 3. With this, I am concluding. Thank you very much.